SJC-12166, Commonwealth versus Julia Leiva.
Mr. Maiden, good morning.
Good morning, and may it please the court. I represent Mr. Leiva, the defendant in this case. I'm here to argue that rule. I'm going to primarily focus on Rule 3.3E, that issue, and then whatever time I have remaining, I'll address any other issues. I'm here to argue that Rule 3.3E of the Massachusetts Rules of Professional Conduct, as applied by the interpretive case Commonwealth versus Mitchell, is unconstitutional as applied to the facts of this case.
So you're asking us to overturn Mitchell?
I think it needs to be seriously modified. Perhaps overturned, but seriously modified.
How would you modify it?
We would start by changing the warnings to the defendant. I would insist on a colloquy. That'd be the first thing. And the second thing I'd do, I'd insist on jury instructions, specific jury instructions to what happened in this case.
What kind of jury instructions would not call attention to the fact that there was a narrative?
I'm sorry, I didn't hear you, Your Honor.
What kind of jury instructions would work that wouldn't prejudice the defendant?
Well, there is some risk that the defendant would be prejudiced. There's no question about that.
And so there'd be mandatory instructions as opposed to ones that the defendant would have to request?
Under the facts of this particular case,
No,
I would say they're mandatory. I would say they're mandatory.
Okay.
I don't see, given what happened in this case and what would happen in the typical case like this, I don't see how the court could not give jury instructions saying, at least saying why the defendant spoke in a narrative, why he addressed the court in a narrative. How would
you do that without saying that his own counsel thinks he's lying? How are you going to possibly do that?
That happened the minute he got up there and entered and gave the narrative. That was absolutely implicit in it. That was compelled. Well, among my brief goes through all the different.
Why is that the case? I mean, I understand maybe if you've got a lawyer or a criminal defense lawyer on the jury or maybe a judge, but I'm confused why a normal juror would know that.
This witness had to be the only witness that was not cross-examined or that directly examined, as the case may be.
He'll be cross-examined, for sure. He'll be cross-examined.
Oh, he'll be cross. I meant direct examination. There was no direct examination. This had to be very unusual when the defense counsel got up and said, Mr. Leiva, what would you like to tell the jury?
So that's right. I mean, but assume that is something the jury would latch on to, but what kind of instruction would you give that wouldn't make it worse? That wouldn't say the reason that we did this is because his lawyer thinks he's lying. I mean, that would be terrible.
Well, the judge could start out by saying that under certain circumstances, the defendant has the opportunity to address the jury.
Okay.
And ladies and gentlemen of the jury, I've ordered that this procedure be utilized in this case. I also order you not to discuss the reasons for this, the reasons why this procedure is being used in this case, just like you're instructed not to discuss whether the defendant testified or didn't testify.
You know, when I was reading the suggestions that you had for jury instructions, I was thinking almost every one of them would create an appeal issue for the defendant if the defendant requested that instruction, or if the defendant didn't get that instruction. That really is bringing attention to something like Justice Gafker said, unless it's a criminal procedure professor on the jury, it's really bringing attention to something that somebody's not necessarily going to know. I mean, one thing you did say, though, that's worth thinking about is that if the judge were to just make an innocuous statement or instruction, that the court determines the mode and manner of interrogation and has a lot of flexibility in that regard. And as to the mode and manner of interrogation here, I've ordered that procedure.
Let me ask you a question. In terms of the narrative, does the Commonwealth typically object? Because it's a narrative?
The Commonwealth object to giving a narrative?
Yeah.
No.
Okay.
No, I don't think, initially, I'm not sure the Commonwealth knew what the rule was. Either did Judge Ford,
So
for
what
that
is
matter.
the rule exactly? Is it grounded in any constitutional right?
No.
So do we have to have the rule?
Well,
Would it
that's
be
a good
better to
question.
eliminate
It might be
it?
better not to have the rule. That's been debated in the literature.
Yeah,
That's been debated. Do we really need something like this?
so maybe it would be better to just not do it.
Well, maybe so.
So then what- then-
There's a, in the amicus brief, they cite a number of law review articles, particularly written by the late Professor Friedman, which has, he wrote 3 law review articles debating this. That's possible. This case is really not about whether the defendant has a right to lie. This case is all about lawyers, okay, and whether in the conflict between their duty to the client and their duty of candor to the court.
What is, I know that the amicus brief also talks about the change in the standard from, to actual knowledge. The rule calls it, it was when the lawyer knows, but that's been sort of
Well, it's actually, I mean,
watered down in Mitchell.
it was certainly watered down. I mean, it certainly, let me address that. The rule actually talks about, the rule 3.3E, or 3.3E
Yeah.
actually talks about knowledge.
Yeah.
Okay, then Mitchell talks about good faith and firm basis and objective facts. On the other hand, it's certainly not beyond a reasonable doubt. Again, the issue is who gets to decide this and what's the standard that's being applied? Is it the jury or is it the defense counsel?
Yeah.
And the defense counsel is under Rule 3.3E has to apply firm basis and objective facts. The jury's told beyond a reasonable doubt in accordance with Webster. And if you go take a look at the duty of prosecutors not to use false testimony, that's knowingly using false testimony. So you got 3 different standards, and the defense counsel is applying the lowest one.
Yeah.
And so that's a problem. I mean,
So which standard do you, if we don't use the beyond a reasonable doubt standard, which one do you think is the best and why?
I think you should use the beyond a reasonable doubt standard.
I
That's
figured.
that to me. I think anyone, and I'm sure some of you have represented defendants in criminal trials. Day 1 you get one story. Day 2 you get another story. Okay, stories change. And
So so if your client tells you he did it, and then he says, I didn't do it,
I'd go with I didn't do it. Not a doubt in my mind about that.
so is that, and that's going to be in every case then, right? When the defendant wants to testify, even if it's preposterous,
Right.
right?
Well, the Supreme Court, the U.S. Supreme Court had a case like that last term, in McCoy versus Louisiana. He gets up and says, "I want an alibi defense. I don't want you admitting my guilt to the jury." Lawyer gets up there and says, and it was a capital murder case, and it was as part of the penalty phase. Says he did it. He got a new trial from the Supreme Court after multiple appellate proceedings.
But so then, again, if there's a change in story, your view is that can never be beyond a reasonable doubt, right?
Well, yes, I think that's a fair statement.
But then you're basically creating a categoric rule then, because we
Well-
wouldn't be here if we didn't have that. If we didn't have, I did it, and then I'm going to testify, it doesn't get any stronger than that, does it?
Well,
We don't know what happened here, do we?
it's not it's certainly not in the record, if that's
Right.
what you're asking. No, that's not in the record. It's again, the role of defense counsel is to defend the client. The client says, "I want an alibi defense," which is basically what he did in this case.
Yeah, but the role of the defense counsel is also an officer of the court, right?
Well, he's an officer. That's right. And again, this is the tension that's been. This problem's been around since at least the turn of the century, at least by the organized bar. And in Massachusetts, it actually goes back to colonial times. Coincidentally, there's a reference in Nix versus Whiteside, which is essentially the only U.S. Supreme Court case on this. And they talk about trials in colonial Massachusetts, and the lawyers were admonished, do not use perjured testimony. Again, this is, this is the interplay between the role of a lawyer in a criminal case and, was the constitutional rights. And
I wanted to go back to that point because you indicated that Commonwealth versus Mitchell and then presumably Nix versus Whiteside is not constitutionally based as far as protecting any constitutional rights of the defendant. I don't know if you want to take that statement back, because I thought that what we're concerned here with is the defendant's right to testify, and whether that right to testify, I thought your position was, is infringed by the Mitchell/Nix v. Whiteside procedure.
That's certainly my position.
Okay, so it is constitutional.
Yeah, well, it is constitution based. I mean, I have to take it apart. In Nix versus Whiteside, the issue is whether the lawyer could threaten the client with, I'm going to tell the court that you're lying. Okay, and the claim there was ineffective assistance of counsel by threatening that. And they said, number one, there was no prejudice because he did testify. But again, that was an ineffective assistance of counsel case. That was not a case involving whether a defendant has the right to commit perjury.
But let's think about that for a moment. What the United States Supreme Court, in analyzing the prongs of Strickland,
Yes.
and this court, in doing so with Safarian and Mitchell, isn't going to come up with a procedure that's unconstitutional. Isn't implicit in the procedure that's ultimately reflected in the disciplinary rule and in the holding of Nix v. Whiteside and Commonwealth versus Mitchell constitutional?
I'm not sure.
Well, let me say
I
it simpler. I mean, the United States Supreme Court and the SJC, when determining ineffective assistance of counsel and how there might be a response to this difficulty, isn't going to draft a procedure that's unconstitutional in the court's mind.
No, of course not. But if you take a look at how it actually gets applied, okay, in the context of the Mitchell case, there's a real problem there. There's Fifth Amendment rights that are putatively violated. There's Sixth Amendment rights that are violated. The right to a fair trial is certainly raised by this. So there's there's a constitutional, I don't want to exaggerate, but there's a constitutional issue on virtually every page of my argument in the brief with respect to this issue. Again, it's the as applied. Sure, look at Rule 3.3. Rule 3.3 is not on its face unconstitutional. It's laudatory. I mean, we don't want lawyers using perjured testimony. But
How would we know that, though? How would we know if the testimony was perjured?
well, you won't. Certainly I don't think defense counsel can flesh that out, unless perhaps most extreme cases. But
What kind of obligation would counsel have if the client said, "Well, I'm gonna bribe that witness so they won't testify against me. Don't worry about that. I'm gonna bribe them."
that hopefully would come up before, not in the middle of the trial. This one happened right in the middle of the
I
trial.
understand that, but I'm just saying that let's just take something else.
If that had happened to me or to
Yeah.
my peer, I'd withdraw.
If it's before trial, you can withdraw.
Certainly before trial.
Yeah.
Once you're in the middle of the trial, this is a different situation.
Yeah.
I mean, the lawyer was between a rock and a hard place. No question. This is a difficult problem. It's been a difficult problem for years.
What do they do when there are bench trials?
Well, that's also, there are law review articles written on that as well. I mean, what do you do when that happens? And
you go to another judge?
well, you could go to another judge. You certainly have a problem going up to the judge who's hearing the case, the trier of fact, and saying, oh, by the way, this is a Rule 3.3E problem, and assuming the judge knows what Rule 3.3 is, and this is not this is not a little bit obscure. I mean, I can't fault the judge or even the judge for not knowing off the top of his head what Rule 3.3 is. Today, if you take the multi-state professional responsibility exam, you're going to know what Rule 3.3 is. You may not know the Massachusetts implications of it.
The rule, I have three questions for you. The rules have been amended. Is there any difference between the rule now and the rule that was in effect at the time?
This was 2016. I don't think so.
Okay. That was question
not
one.
Not to my
All
knowledge,
right,
anyway.
Question one. Question two is, do you think assume that we're not going to make any changes, assume that the protocol is as set out in 3.3E and in Mitchell, did the lawyer do anything wrong in the way he did it?
No. I've thought about that. I don't think so. The lawyer did, he called it's on the record, he calls the Board of Bar Overseers,
I know it.
you know, the night before, said, well, what do I do?
Yeah, and then he does whatever they tell him
Yeah,
to
and
do.
he did exactly what they told him. How can you say that it was, unreasonable performance under the circumstances when he did exactly what they told him to do?
Yeah.
So I can't question it. I can't really question the lawyer based on the facts in the record,
Yeah,
okay? But I certainly can question the implications to the defendant of what happened, what happened to him.
yeah. The third
And-
question I have is this, which is, I can't tell whether you're arguing an ineffective assistance of counsel. In the brief at 29 to 33, you claim the defendant's right to effective assistance was violated, but in note 24, you say that the defendant does not contest the adequacy of the counsel's performance in invoking Rule 3.3E. So I don't know whether you're doing that, invoking ineffective assistance or not as to the other claims.
I don't think so. I'm not sure. I didn't read
maybe-
I didn't
maybe-
intend to write that way. I'm not aware of,
I couldn't tell, so I just wanted to clarify.
yeah, no, I don't think, listen.
You're not raising ineffective assistance at all
No,
now?
I thought Attorney Black's a very experienced lawyer. I thought he did a decent job. I thought, good job. I mean, at least let's put it like this, not constitutionally deficient.
Okay. I just want, it wasn't clear to me what you were doing. And,
Yeah.
So
I understand.
there is certainly a quite interesting issue as to whether we should revise Mitchell and how we should deal with 3.3, but how does any of this help your client? He apparently asked the judge to not give a jury instruction, correct?
Attorney Black, that's right.
Okay,
That's right.
so it's a little bit hard to argue that he was prejudiced by the failure of a jury instruction
Right.
when,
That's right.
so the colloquy, are you arguing that he was, that a colloquy would have had consequence, or that something would have,
I think a colloquy would have done wonders in this case, Your
to
Honor.
do what?
I would have started right from the beginning. I mean, if you take a look at what actually happened, Judge Ford essentially asked one question. He said, did Attorney Black tell you about the rule? And he goes, yes, he told me about the rule. That was the colloquy. I mean, it's right in the transcript.
So
Okay?
what-
But I would suggest a much more thorough colloquy should have been done, starting with the admonition, almost like a right to counsel colloquy, along the lines of, well, I'm not here to tell you not to testify, and I'm not here to accuse you of lying, but you need to understand that telling the truth is very important. And you can word it any way you want, but the bottom line is at least an attempt to dissuade him from that, and then go through and say, let me tell you a little bit about the implications of this. You're going to testify in a narrative. You're going to be the only witness who testifies in a narrative. And then your lawyer is not going to be able to argue anything you said during your testimony. Now, do you really know? I want you to understand all these things. You can go talk to your lawyer about this. And by the way, this involves a limited forfeiture of the right to counsel. Okay? That's essentially what happened in this case. And maybe you want to represent yourself in accordance with Ferretta. You have the absolute right to represent yourself. Maybe you want to give your own closing argument. Lots of things could be said in
My
a
goodness,
colloquy.
putting,
But, well, I mean, if all of that was said, somebody would be here to argue that the judge was depriving him of his
Well,
right to testify,
that-
and that was encouraging him to do the foolish thing of abandoning a perfectly good attorney to be representing himself when he wouldn't have a clue what to do and hadn't prepared for it. Why is that?
My answer to that is that's the same issue that comes up when theoretically, when you give the colloquy about your right to testify and you're making sure the defendant knows his rights.
That's a
You're-
different,
you're-
I've given that colloquy many times.
I'm sure you
That's simply
have.
to say that you do have a right to testify, and the decision whether to testify is your own, and you may confer with counsel, and I encourage you to do so, but ultimately, the decision as to whether or not to testify is yours and yours alone, and that's at least the colloquy which I would give, and then I would say, I'm not gonna let you, I will find out what your decision is during the course of your case in chief, but that's a very different colloquy than the one that you're talking about.
Well, that's certainly a risk. On the other hand, given what we see in the transcript in this case, I think that was a risk worth taking. That's the best way I can answer
Is that because you want the colloquy to be adequate so that the guy can waive his constitutional rights? Is that a waiver of his constitutional rights? If you have a colloquy that's adequate, according to your lights,
Right.
Is that a waiver of his constitutional rights?
I don't see how.
Why not?
He's not waiving his constitutional rights. I'm advising him of the implications of him exercising his constitutional rights. I don't think he waived anything.
He hasn't waived anything.
I don't think so.
Okay.
So let's assume we say you're right to the extent that the standard here should be re-examined. How is it going to help your client? It may be as to you know, if we change the standard from firm basis on objective facts to something else, how is it going to help your client here?
I see my time is out. May I answer this question?
Yeah, try to answer that one.
Okay. My answer is that aside from changing the rule, okay, my answer is you should order a new trial. That is the answer. And see what happens the next time. That's the best answer I can give you.
Chief, can I ask a question on one other issue?
Sure.
So you have an issue with the substitute medical examiner?
Yes.
Could I
do.
ask you one question of that, please? The surgeon is present when the alleged victim dies in this case?
Meaning at Bay State, at the hospital. Yes, the surgeon was there, and she did testify, which I thought was a little bit unusual. She addressed what the injuries were and things like that.
Well, you anticipated my question. How can there be any reversible error if your complaint is that the substitute medical examiner is giving testimony that, concerning testimonial hearsay concerning cause of death, but there's a precipient witness who testifies to the injuries and the cause of death?
Yes, there was a precipient witness who was a doctor and was a trauma surgeon, but she didn't perform the autopsy. I mean, and certainly the substitute medical examiner did not base any of his conclusions on her testimony.
No, I'm trying in this question to, I also want to know exactly what was testimonial about the expert's testimony, but that's not my question. My question is let's just assume that you're correct, that the substitute medical examiner's testimony was violative of the Confrontation Clause. Where is the harm if we've got a precipient witness who's talking about the injuries and the cause of death?
The best answer I have to that is that the precipient witness did not perform the autopsy.
Okay.
But precipient witness, the autopsies look much farther than just the wounds. I mean, they go through as one medical examiner, I think, testified in one of my cases. He said, "It's your last physical exam. I'm going to find out what else was going on with you." We don't know. She didn't do blood work to determine whether there was any illicit substances in his bloodstream. But again, the effect of the series of rulings that this court has issued involving substitute medical examiners means you never have to have the real medical examiner. And the only way that a defense lawyer gets to find out what happened was by basically trying to cross-examine, and only on cross-examination, the substitute medical examiner. Well, what was in the autopsy report?
Can I just...
That raises confrontation issues, and quite frankly, I don't think it's fair either.
Just one more question, please, that I'm not sure I was able to figure out from your brief. What was the testimonial hearsay from the substitute medical examiner that you're alleging? What was testimonial about his testimony?
I don't know that I alleged that there was something testimonial. The
Okay.
problem was you couldn't get at the original medical examiner. And by the way, we're not sure why she didn't show up. But aside from no longer being an employee of the Commonwealth.
But you're saying, the reason I didn't understand it from your brief is you're saying that the substitute medical examiner's testimony, nothing that the substitute medical examiner testified to was testimony.
No, he was smart how he did this. Okay, he did not say, "Here is the autopsy report, and let me read it aloud." He did not do that kind. He certainly said, "I considered it, and I based my opinion on it." But again, you never get to the substitute medical examiner in any of these cases.
Is it the substitute medical examiner, or is the data underlying the examination?
I'm sorry, I don't
Is it the
understand.
data that you're worried about? Is it the accuracy, the reliability of the data underlying?
Certainly. You
That's
can't.
what you can't get at that.
You
because
can't get at it.
Yeah, that's what you're worried about.
You certainly, you can't get at that, you cannot get at the underlying findings of the original autopsy,
So if you had
short of exhuming a body.
so if you had somebody who was drunk or who was, incapacitated while they were doing the autopsy, the findings could be crazy, but somebody else could base an opinion on them. Is that the problem?
I'm sorry, could you repeat that?
I'm sorry. I'm saying that, if you had a drunk or an incompetent medical examiner the first time round and who came out,
You certainly would.
you couldn't get at that.
That's a very
what
good point. You'd never find out about it.
That's right.
You'd never find out about it. The substitute medical exam say, well, I looked at the pictures, I read the report, and here's my opinion.
Yeah, based on crazy facts.
Based on a guy who's incompetent.
Yeah, okay. I wanted to make sure I understood it.
No, that's a good point.
All right, thank you.
Thank you.
Mr. Shepherd Brick, good morning.
Good morning. May it please the court, David Shepherd Brick on behalf of the Commonwealth. The defendant asked this court to overturn Mitchell, but has not identified any compelling reason showing that the reasoning of Mitchell was incorrect or that it has proved unworkable. It's obviously a difficult situation when an attorney faces the prospect of client perjury, but the invocation of the rule and yet allowing him to still testify in the narrative is the best, sort of making the best of a bad situation.
But part of my concern about the rule, and it's certainly a very challenging problem, is we know a lot of defendants testify and that a lot of juries conclude that they're not telling the truth.
Yes.
And nobody really claims that the attorney violated Rule 3.3 by allowing perjured testimony to go forward. So I don't blame Judge Ford for not knowing Rule 3.3 because I don't think I ever had a case in 11 years in Superior Court when it ever happened. Does that mean that the way that a defense attorney avoids a 3.3 problem is simply to not ask the defendant very much about what happened? Because if he doesn't tell you he did it the first time, then you're not stuck in the situation when he says, oh, I didn't do it, to be in a Rule 3.3 posture. So you're not inviting a great deal of information from your client in order to protect you from this predicament. And is that a good thing for our overall system of justice, where we are essentially discouraging defense counsel from being able candidly to speak to their clients as to what exactly happened?
Well, I understand the difficulty with balancing between you want counsel to be able to speak to the defendant. I think the fact that it doesn't get invoked often is indicative of the fact that the standard that we have now is more than sufficient. I don't know that it necessarily causes defense counsel not to speak to their client. The court suggested in Mitchell that the beyond a reasonable doubt standard would essentially require that the defendant confesses to the attorney and then says he wants to get on the stand and say that he didn't do it. So I don't know that really affects the communications between lawyer and client. Also, as officers of the court, we want to have the public to be able to have faith in the system. So the idea that we should just dispense with the rule and just say, because the defendant has a right to an attorney, we don't want to interfere with that right in any way. The attorney can just is forced to do something that would otherwise be a gross ethical violation.
So when is it, I'm reading from Mitchell, the standard mandates that a lawyer act in good faith based on objective circumstances firmly rooted in facts. And so they seem to adopt this standard of based on objective fact. But in this particular case, you had an eyewitness who knew the defendant well see him carrying a sawed-off shotgun and blowing away her boyfriend. Is the defense lawyer supposed to say, come on, that person's entirely credible, there's no particular reason for her to lie, the case against you is overwhelming, your story's ridiculous, I'm not going to put you on, and I'm going to now not let you go on because I know what the jury's going to hear, and it's ridiculous.
I mean, I think that is probably what the conversation was. In addition, I mean, there was more evidence than that. I think the evidence of his guilt was overwhelming. The security video is fairly incriminating, showing him someone who he inadvertently admits is himself, and then says that it wasn't him, carrying an object consistent with a firearm, locking the door so the police can't get in, and then he confesses to the friend who picks him up that he was involved in a robbery at that address. So I don't necessarily think we want to discourage that conversation. In fact, that's what Nick says, that we want that conversation to happen because defense counsel, prior to the defendant testifying, had presented the best defense that was available to him. He vigorously cross-examined the recipient witnesses. He made sure to highlight the lack of lighting.
Poor police examination? Was poor police work?
Yes. He tried to show that the scene had been compromised, that they hadn't properly secured the scene. There were a number of different avenues that he covered.
Why don't we raise the standard, though? You know, if you do this long enough, you hear a lot of preposterous defenses. The jury has to convict beyond a reasonable doubt, but the defense counsel is supposed to give up and bring this 3.3 notice to the judge when there's a firm basis, which is a lower standard. It seems like there's a bit of hypocrisy in the whole thing. I guess the question is, should we require, if he confesses, you can't go forward, or if he says he's done it, you can't go forward, but otherwise, you know, this is a jury call. I am worried that there's a level of subjectivity to this that, you know, anyone who does this a long time knows a lot of these things are ridiculous, the defenses. And I don't know what a firm basis means. It seems like it's a pretty low standard. But go ahead.
Right. Well, I think Justice Greene in Mitchell sort of explained the rationale behind that.
I think the rationale is perfectly logical. It's where we set the standard for when defense counsel needs to come forward and says, this is a 3.3 problem. And I am worried that the jury is finding beyond a reasonable doubt in this huge percentage of cases where lawyers are going forward and they know the exact same facts.
Right.
Maybe, and they know more facts actually than the jury does.
Right. Well, and I think what Justice
For
Greene.
example, like when a motion to suppress has been, you know,
Right.
allowed, you know, and you're going forward there, you obviously know more facts. You can't consider those facts, but it just seems like there's a level of confusion here.
Right, and I think the reason for the lower standard was to prevent the perjured testimony in the first place. You know, there's the suggestion that you know, Justice Greene said in Mitchell, the standard would also tend to compel defense attorneys to remain silent in the face of likely perjury that a sharp private warning could nip in the bud. So I think that's the rationale for the middle tier standard. I understand the court's concern, you know, the jury has to find beyond a reasonable doubt. I think, I don't think if the court raised the standard that would affect anything that happened in this case. I believe that.
Would it provide clarity to defense counsel so that they're not in this bind, or they're not, I mean, I haven't read these law review articles that say when lawyers are paid, they don't present 3.3 arguments. When they're not paid, they do present 3.3 arguments. there's something a little bothersome about that.
Right, but I mean, I think the concern is not so much the standard. It seems like when they are not bound by, when they're not pulled in one direction by financial concerns, they're able to do their ethical duty. I mean, I know that's...
Or ignore it. Or ignore it.
Right.
But I'm not sure, I mean, I have to say that, having been aware of this issue for a long time, including the 19 years that I was a trial judge, I have to say that there were no cases in which this was raised. And I think that criminal defense lawyers, they're officers of the court, they consider this matter seriously and take their obligations seriously. And based on that, I just wonder if the standard is really causing difficulty if we almost never see it. I mean, in fairness, I can't say I never saw it, because maybe once or twice in 19 years, a lawyer would come to the sidebar and ask to withdraw, and maybe cryptically I'd be able to figure out well before trial that was the reason, but I'm not sure. But absent that a couple of times, it just never happened. So how difficult is this to be able to manage for defense counsel?
And I think that's the lack of cases is telling, that it has proved a workable standard, because we don't have...
Or has it proved to be a standard that's just honored in the breach?
I suppose, I mean, the thing is, it's not... We don't know that it happens unless the lawyer invokes the rule. So it's
And what would happen before a bench trial?
Well, so there are two different schools of thought on that.
Mitchell didn't deal with that.
No. There are there's a federal case that has said that that it's not a proper procedure for a bench trial because the judge has been told. Other cases other jurisdictions have said, no, that we trust the trial judge to be able to set that aside. I'm not sure how workable that standard is, but we're not presented with that. There was a jury. So
Maybe go to second session?
Can I go back to the facts? I was perplexed. Is the view here that the motive was purely robbery? This is a perplexing crime.
It is. I think the view was that I think they were checking his pockets for weapons before. I think there was a suggestion that that's why they ran his pockets before the shooting.
Yeah, but why did they shoot him?
He was the defendant. The victim was dating the defendant's ex-girlfriend.
Yeah.
Who the night before they're captured on surveillance camera, and the defendant is being very affectionate with the ex-girlfriend. She does not appear particularly enthused, but I think that that's probably the best explanation.
Well, that makes more sense than some of the others. What did the defense counsel argue in closing? And, I mean, your brother says that there was prejudice because the failure to be able to make reference to the testimony prejudiced him. What was the argument in closing by the defense counsel?
The argument in closing was essentially that first, the eyewitness was wrong about one of the people she identified. The police didn't thoroughly investigate. It was a combination of the eyewitness was mistaken, lack of I mean, he requested a Bowden instruction several times.
If no one has any other questions about this issue, may I ask you about the confrontation clause, please, Mr. Shepherd? Thank you. So, am I correct that the appellant's brief doesn't really point to anything specific that the medical examiner testifies to that would constitute testimonial hearsay?
That's correct. He did not refer to the underlying report. He said he reviewed it. He said he reviewed the photos, which at the time of his testimony were admitted into evidence. They were later stricken. I guess they decided that they didn't want the jury to see the gruesome photographs.
So what about, I want to come back to that in a moment, but what about the surgeon being a witness and the surgeon seeing the victim die and where the bullet holes were and everything? Even if there had been something that was testimonial hearsay, does that address any potential harm from?
I mean, I certainly would agree that that shows that there's no prejudice. You have a medical doctor with, who's been a surgeon for, I think it was 20 years, and she testified as to the wounds, that they located a bullet while performing surgery, and that he eventually died of those wounds. So I don't know if there's any prejudice.
So one last question. I suppose we don't really have to reach it, but DYS versus a juvenile and Commonwealth versus Nardi all talk about the evidence doesn't have to be admitted, but it has to be independently admissible for the expert to rely on it.
Right.
So and one way to do that is to have photographs taken during the autopsy and to have oftentimes a trooper in there, for instance.
Right.
So in almost every case, the medical examiner can rely on either the photographs admitted or the photographs that aren't admitted but would be independently admissible.
Right.
When Judge Ford strikes the photographs, does that eliminate the DYS versus juvenile and Commonwealth versus Nardi concerning the photographs because we have a ruling that they were not independently admissible?
No, because the reason he struck them was the prejudicial effect over probative value, not that they weren't otherwise properly admissible. And so I think they would be admissible, and they were admitted, and I think it was just a concern of prejudicing the jury, not that.
So independently admissible means theoretically independently admissible because it's probative, but in determining whether something's independently admissible, we don't consider weighing that theoretical admissibility against undue prejudice in a specific case.
Right, it's about the
position?
reliability of the evidence. So if the evidence would be excluded because it were not properly authenticated or couldn't be properly authenticated, or something that went to the reliability of the evidence itself, here the exclusion was simply that it was probative, but that it would have inflamed the passions of the jury.
Let me explore with you also the example that I gave to the other counsel, which was suppose you had somebody who was really kind of incompetent or drunk or something who was doing the autopsy, and crazy facts, but that's what you have. And then the substitute looks at that and opines on the basis of it. But you could never get at the underlying unreliability, could you?
Well, I'm not sure I agree with that. You could certainly, I mean, you're allowed to cross-examine the expert on the basis for their opinion.
But how would they know that the facts were crazy or inaccurate in certain respects? Because they're relying on them.
Well, certainly as to the report, I mean, again, I don't know. I'm not a medical doctor looking at a report.
I understand that.
So I don't know if there was something you could look at and say, boy, this doesn't look right to me. The things that this prior medical examiner wrote down don't seem to coincide, especially when there are pictures. Here there are photographs through the autopsy. So I think that eliminates that concern to a certain extent.
To a certain extent only, though.
And beyond that, I mean, I guess it's, I mean, defense counsel did certainly address it with the medical examiner, did say, you didn't see the body, you weren't present, all of those sorts of things to at least put that before the jury so that they could consider, what he was relying on.
Was the objection preserved, though? Because the objection was to having a substitute medical examiner there, so it's not the actual medical examiner. The objection was not to whether or not the testimony constituted testimonial hearsay, or whether or not there was a basis for the opinion. It wasn't even an objection to Nardi or DYS versus a juvenile. Is the objection preserved?
Well, when he was arguing, he did say that it's a confrontation issue. So to that extent, I think that may preserve the issue. I don't think that the standard review is going to change because.
No, I understand that. I'm just wondering if it's preserved if the objection is to any substitute medical examiner as opposed to the specific testimony of this substitute medical examiner.
He renewed his objection during the examination. He said for the reasons already stated or something to that effect. And he did raise confrontation in his opposition to the motion to eliminate. So I'd say that's probably preserved.
Okay, thank you.
If there are no further questions, I'll rest on my brief.
Thank you.